Order dated 3rd of August 2023, my lord. One matter.
What do you want?
My lord,
Straight away.
Our submission is not completed, my lord.
No, Kichuna. Then you'll have to take out an application. This can't be done on a mentioning.
My lord,
This can't be done on a mentioning. Sorry.
my lord, may I have your lordship's kind indulgence, my lord, with respect to item number 141 of today's list, my lord.
Yes,
This is the only appeal hearing, civil appeal hearing.
it's not possible for us
No, my lord,
because of
kindly
the.
fixes a date, my lord.
No, this can't be done because of the compelling circumstances which we experience today. Because the division bench will not be available from 2 p.m. for rest of the circuit. One of the member has to leave the circuit bench. Now we'll be functioning with 3.
I understand.
So this is not possible.
Then, my lord, may I pray for one thing, my lord? There was a direction for on the appellants, my lord, to file paper book. My lord, I'm suffering an my lord, ad infinitum injunction, my lord. They have not yet filed.
We'll consider it.
Very good.
Yes. Whose order?
So order was passed with the last subject, lordship.
Before him on virtual mode. Yes. Call the list. Yes, the SP of the Alipurdwar.
As per the direction of the
Correct.
honorable superintendent of police Alipurduar is
Yes.
present, my lord.
Has he gone through the order of the earlier division bench?
Yes, ma'am.
Has he understood? I think he is an IPS officer. He understood the English language. He understands what is meant by that. Then why this? I do not know. This memo or the order is
Details of this, sir.
done.
This communication, my lord, to public,
Whether the order of the division bench was communicated to him, tell me.
yes, ma'am.
Then he read that order.
Yes, my lord.
If he read the order, then what was the order? He must understand
My lord. On
the spirit. Then why he say that all this SIT will always give him the information relating to progress of the investigation? That's the language. May I read that?
That is my lord.
I am asking you. I am just asking you, sir. Telling you what is this language?
My lord.
This copy has been forwarded to us, which says that in compliance with an order dated 16/6 passed by the circuit bench of the High Court at Jalpaiguri in such and such matter, the special investigation team
See,
is whatever. I expressed in a full form, not in abbreviated form. Is hereby formed. That was your job. You have to form the SIT. And following police officers the following police officers of the Alipurdwar are included in the special investigation team. The officers will communicate any progress of the investigation to the undersigned. Why this word was given? I just wanted to know why this sentence was written when the order was very categorical, explicit, lucid in all sense, which says that the DIG will monitor the entire functioning of the SIT. It is only the responsibility to constitute an SIT was entrusted upon the officer. Nothing more than that. Nothing more than that. Then what is what is the meaning of this word? Since the matter is of a great concern, I am reading paragraph 4 of the order dated 16/6, which we find the reference from there. Since the matter is of a grave concern, and till date the victim has not been recovered as yet, we direct the Superintendent of Police, Alipurdwar, to constitute a sit, which must include a senior rank officer of the CID and the SIT shall function under the supervision of Deputy Inspector General of Police, SBI Special Crime Branch. The entire investigation shall be carried out under the strict supervision of the Deputy Inspector General of Police, CBI. What does it mean? Then why you wanted to retain a control over the progress of the functioning of the SIT? Under what circumstances you can?
My lord, the order has been passed on 16 June 2023.
Correct.
By the coordinated bench of this court.
Correct.
And thereafter, on the very next date, that is 17, the order has been, as per the order, my lord, on 16th order, the seat has been formed, my lord.
Fair enough. Very nice. Very good.
My lord,
That alacrity we appreciate. No difficulty.
my lord.
No difficulty.
And the,
But that sentence really creates a problem.
and my lord.
Why the sentence was written?
It's communication, my lord, the extreme communication of the district, district order, my lord.
What district
Kindly
order?
confirm to- It's a district order, my lord.
What district order means? I do not understand it. What is the meaning of this word district order?
This is an order passed by the superintendent of police
Yes,
and to the member of the seat.
correct.
This is the.
This is what we understood.
This is the order.
Yes,
And
this is
the-
what we understood.
the three officers under SP Alipurduar. They are sorry, they are not superior officer of superintendent of police Alipurduar.
Correct.
That's why that order has been communicated to the seat members. And thereafter, my lord, on 24th, this order, my lord, communicated to the CBI. This order, my lord, on 24/7/2023, the same thing has been communicated to the CBI by the SP Alipurduar. Second paragraph of this publication, my lord. The order indicates that the seat should function under supervision of DIG CBI special branch. In view of this, it is informed that the seat has already been constituted by DD number so and so dated 17 June 2023. This is for favor of your kind perusal and necessary action, my lord. So there is no
Mr. APP, do you have any experience or a knowledge of the functioning of the administration side? No.
I have.
Sir, when an officer below the rank of the higher official, if he is directed to do a particular thing in a particular manner, do you think that those officers would defy the order of the senior? What was the necessity of writing that sentence that every time you will report him regarding the progress of this? Is it not a transgression of your, it is not a transgression of your jurisdiction? Are you not overreaching the court in all sense? When a court has very categorically said that your job is to constitute the sit, that's all. Not beyond that. That's the full stop there. No, sir. He is an IPS officer, unintentional mistake. He understands English language. He has completed the examinations, secured a rank in the examination. Do you feel that I can understand a constable, I can understand an SI, he can, but not a stature of such person that he does not know the meaning of those languages, and he has not understood. I fail to understand this. Why? Is it not a usurpation of the power of the court? Is it not that you showed least sanctity to the majesty of the court? Is it not? Why you will direct? And can you imagine that these officers who are the constituents of the SIT, if those mandates are given, what they will do? They have nothing to do on that.
Madam, this order is only timing for supervision of this.
Why?
Not
Why? Have you not understood the tenet of paragraph 4 of the order dated 16/6? Have you not? It is very, very clear. I think as clear as the Ganges water at Gangotri. What more? Yes. Maybe your intention, but what is apparent? What is apparent is from the language which you have used in your letter. Yes. Yes. Correct. 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 That is under the normal circumstances, sir. This is not a normal circumstances. The investigation lies with the investigating officers in relation to any offenses that has been committed. So you can monitor the functioning of the investigating officer in those normal circumstances. When the court has said that you will not monitor it, you will not supervise that particular functioning of the set, then why you say that you will report to me every time regarding the progress? Why you want? Why you? Yes.
The court has when the function to the ADC till the time being till the time being when CPA shall communicate that we are taking this to.
Who will communicate to you? He will never communicate to you. Why he will communicate to you? What is the purpose of constituting an SIT? No, he will have a direct control. So far as the supervision is concerned, the functioning of the SIT is concerned, he is a person who is responsible. If something happens and if the SIT is not really functioning in a proper manner, who will be responsible? You or the DIG CBI? The DIG will be responsible. He is answerable to the court that what supervision you have done.
After the consideration of SIT,
Yes.
after the communication of the High Court order, the
Correct. Their communication will not come because their communication, their job starts the moment you constitute a SIT. The moment you constitute an SIT and then you inform them that you have constituted an SIT. Now thereafter, it is now their role, what they will do in terms of the order. But when they receive this order, that shows that you are really overreaching, transgressing whatever was given by virtue of an order of the court. You are transgressing your limits.
If I have this
But then why you have written this? All the progress must be reported to you. You are not supposed to know everything and anything of the SIT. You're not supposed to know.
Writing was a modified order, modified this order and.
No, it's not a modify. That he is answerable because it is his order. He has to consider it.
Let him become this order and direct him to comply the order, the terms of the court.
What is the misunderstanding? I have read the order. I said the order is absolutely clear, explicit, no difficulty. I think there cannot be any ambiguity in the mind that the court intended that the SP should have a control over it. And secondly, the DIG CBI, I understand in a hierarchy, is a superior officer. He's a superior officer in rank. And then everything is to be reported to a junior officer. That was an intention, it appears. That is what we wanted, that this kind of a problem, because the entire records are gone. I do not know, evaporates or what has happened. And there was a serious issue. And the court took took into account those. And the court wanted the SIT because the court does not want any other person to do it.
So when they comply the court's order, Whom do they consult? You, that is APP, or they have their law section regarding compliance of the court's order?
No, no, he has, as an SP of the entire thing, he has a control over all these subordinate stuff.
But this is the compliance of the court order.
No, that is a different, that's why I'm saying, this is not a normal affair.
So he
He has been-
controls of the law section of the APP.
I do not know every time.
That should be done in serious matters. You should take consultations in the legal cell or to the APP.
No, my view is when the order is absolutely clear and no discrepancy, neither an ambiguity can be seen from there. There's no necessity. You are an educated person. You know the language. You know what it mean. Then where is the difficulty? Why you will write that sentence that all the progress must be reported to me? Why? The court has not entrusted this kind of a job or a job of supervision to you. Only was to constitute an SIT. That's all. That gives a wrong signal, sir. Something which is on a hindsight is being projected up front. That is what we think. Yes. Nothing. The order is very clear. You'll have to supervise the entire functioning of the SIT. Now the SIT has been formed. Continue. And if any difficulty, you can approach the court.
As per the order, paragraph 4, one officer of CID crime branch would have been included.
That has been included.
No, not from CID. He'd not been included till now.
Which one?
DDCID is a superior matter. DDCID has been.
No. Let me see. Now, what do you want to say?
The Anirban Mojumdar, WPS
Just,
Deputy SP Crime Alipurduar.
Yes. As a nodal officer. He says as nodal officer. And then
My lord,
who?
the order says there should be a senior
one
officer.
I have seen.
That's
It says that a senior rank officer of the CID.
CID. It's
Correct.
not from CID.
Show us.
We received the communication from on first August, madam.
Show us. Who is this gentleman? He is in CID?
CID, madam.
He is
DDCID.
posted in that? Is posted in that department?
Yes, madam.
So where is the difficulty? Where is the difficulty?
We did not get this memo, my lord, till now.
So where is the difficulty?
Now they are telling before the honorable court that we are included.
The law is, if an order is passed by an administrative authority and keep that order in the file and did not communicate, it is no order in the eye of law. There are a Supreme Court judgments to that effect and says that nothing. If you have passed these orders in the month of July, 31st July, what prompted you, what constrained you not to communicate this? Now, this is the 31st July I find at the bottom. This is what I find.
We received on first August.
What we received. This is by him himself. This is by him himself or a headquarter. Sorry. Oh, this is the headquarter CID.
Yes.
Yes. Now I understand. This was the headquarter CID.
It was found, we come to know in the court today. And we are supposed to monitor.
Yes, function it. Do it.
Lordship, if my lord, my lord
and
can give us.
As and when the DIG, the crime, I do not know, CBI crime, what is his designation?
DIGSCP.
CBI, Special Crime Branch. Whenever he wanted all these constituents of the committee, the SIT, they have to report to him directly.
And my lord, one liberty, my lord, if the DIG can nominate a few persons through SP to be included in the seat.
No.
Then we have to go before
That
the
would,
original.
yes, that means a variation,
Lordship.
modification
Might not got your point.
of the order, which we can't do it.
Lordship will.
Which
if
we can't do
necessary,
it.
You have to go before the bench that passed the order.
That's all,
My lord.
which we will not do it.
That order is going to be expired. No, he has come that from his communication and he will rectify that. That's what we.
Pursuant to the order dated 7th August 2023, the Superintendent of Police Alipurduar is personally present in court today. Stop. The reason for passing a direction for personal appearance of the said high rank officer was necessitated because of the memo dated 17/6/2023 issued by him, constituting the SIT in terms of order dated 16th June 2023, passed by the earlier division bench in the instant matter. By the said order, the earlier division bench directed the investigation to be conducted by the special investigation team within bracket SIT, to be constituted by the Superintendent of Police Alipurduar, which would include a senior rank officer of the CID. It was categorically indicated in the said order that the entire investigation shall be carried out under the strict supervision of the Deputy Inspector General of Police, CBI, within bracket Special Crime Branch. By the memo dated 17/6/2023, it appears that simultaneously with the constitution of this SIT, the constituents thereof were directed to communicate any progress of investigation to the said officer, which was never intended by the earlier division bench at the time of issuing direction on 16/6/2023. The explanation is sought to be made before us that because of having administrative control and being the high rank officer, is supposed to monitor the functioning of the subordinate officers, and precisely for such reasons, the said sentence was included in the said memo. The SP Alipurduar submits that he never had any intention to subvert the direction passed by the High Court, nor any intention to overreach the powers entrusted upon the court. Full stop. We find such explanation. We accept such an explanation and do not intend to move further, with the caveat that the SP Alipurduar would take an appropriate steps for clarification and/or issue an explanatory note in this regard, which should be in tune with the spirit and the soul of the order dated 16/6/2023. Immediate. Under DSG, submits that by the said order dated 16/6/2023, this court directed that the sit must consist of a senior rank officer of the CID, which does not appear to be so from the said memo dated 17/6/2023. Our attention is drawn to a memo dated 31st July 2023 issued by the superintendent, the special superintendent of police within bracket headquarter, CID West Bengal, that one of the constituent of the SIT belonged to the said department, and therefore we do not find any deviation from the said order while constituting the SIT. Stop. It is, however, made clear that the SIT would function under the strict supervision of the Deputy Inspector General of Police, CBI, within brackets Special Crime Branch, and shall follow and obey the directions passed in this regard as and when so warranted, and the police administration would render all cooperation and assist all cooperation to the said officer in discharging the duties and the functions entrusted upon him by this court in terms of the order dated 16/6/2023. In the event of any further directions warranted, necessitated by any special circumstances, the liberty is given to the Deputy Inspector General of Police, CBI, within brackets Special Crime Branch, to approach the court in the instant matter. Whether it is required, it is not a contempt jurisdiction, sir, that the rule has to be discharged. It's not a contempt. Anyhow, the further appearance of the SP Alipurduar is dispensed with for the time being. Is dispensed with until further. Yes.
Hello. Pursuant to the Hon'ble Court's direction passed on 7th August 2022, the petitioners are beyond the defective
Yes. What is this?
For the appellate lordship.
What is this application?
In fact, this matter, you will find that there.
Oh,
is
your
a final
condonation,
degree.
condonation application has been allowed.
Yes, contribution that has been allowed.
Correct. Now, what is the application?
In this appeal, I cannot find the degree as passed by the lower court. Since there is no. Degree
What is the matter
like-
about? What is the matter about?
And on the last occasion, this to direct the.
Oh,
pastoral
I
affairs
understand. Correct. What is, why we directed?
because the final degree is lying with the respondent.
Oh, this is that case. Where is have you taken the original one? Yes. What was given to you? What was given to you? Show us.
There's not two.
Who got it? Who is she's a plaintiff?
No, then.
Who is appearing for plaintiff? So you are a plaintiff.
Yes, then.
Where is the original finally? What are you taking? We were very categorical. Has he not communicated to you that for what reason we wanted?
Yes, of the.
Bring that tomorrow, the original one. Original final decree. We wanted you to bring it. And then we will, thereafter we will take steps against the judicial officer. Bring it first tomorrow.
Grateful, Lord.
Order should do so final order, original order is going to be. There is nothing in the.
Small typographical mistake are they were corrected also. Can you see that? In paragraph number 3, line number 5, the last portion. The principal accused, another principal 1. The next part is who is still in custody, but he is not in custody.
Yes, which paragraph?
Paragraph number 3,
Yes,
and the line number 5. That is the last line.
paragraph number 3.
Why is not in custody? Absconding. Recall the order and then we have dismissed it.
No, if you are possible, if you allow the application.
No, then we will dismiss it.
Proceed further.
We'll dismiss it. Recall the order. We are recalling an order and we'll dismiss it.
Yeah. Other is not responsible.
No, we want it. Has he got a bail or no? Has he not been arrested?
Petition number 1.
No, petitioner number 1, son of principal.
No connection with his father.
I am no connection,
No connection.
no biological connection.
Yeah.
You say no connection
No.
is a very wide
Both are
term.
accused in the case. Accused in the case, both are accused.
Where is your son?
I don't know, he's not living with me since last couple of years.
Couple of years.
For that reason, for my. As usual, parent, I have not seen, I pray about that. Typographical mistake maybe.
দেখো who is still absconding করে দাও যাতে proclaimed absconder who is still in custody বলে দাও who is absconding.
People of life.
Grateful, man.
Superintendent of correctional home communicated.
Medical board has been constituted. Why not? Why not?
There is no response from the part of the SSKM, superintendent SSKM.
2 times we have communicated the order.
No, no. Medical board constitution. তো কন্টেন্ট হলে এটা আমার অর্ডার নয় বলে কিছু করতে। By an order, this matter has come up for extension of the interim liberty granted to the petitioner. For extension of interim liberty granted to the petitioner. By an order dated 15/6/2023, the petitioner was granted interim bail for a period of 8 weeks on a condition that the petitioner shall report to the Bhatigara police station once in a week through telephone/mobile phone if his physical condition does not permit. First off, the said interim bail was granted on taking into account that the petitioner is that the health condition of the petitioner is poor, and direction was passed upon the superintendent SSKM hospital to constitute a medical board to examine the petitioner and file a report within a week after the said examination. We invited the attention, we called upon the learned advocate appearing for the state to apprise us whether the petitioner has been examined by the medical board to be constituted in terms of the said order. Comma. It is submitted. It is fairly submitted that the superintendent Siliguri Special Correctional Home have communicated the said order to the superintendent SSKM hospital, and even a reminder was given to constitute a medical board and communicate a date so that the petitioner can be taken before the said board for examination. Till date, no response is shown by the superintendent of SSKM hospital, which is a matter of grave concern. We therefore direct the superintendent of SSKM hospital to immediately constitute a medical board within 2 weeks from the date of the communication of this order. And semicolon, correspondingly, the superintendent Siliguri Special Correctional Home is also directed to take the petitioner before the medical board as and when so communicated, and submit the report within 2 weeks after, within a week after the examination of the petitioner by the said board. In view of the facts, we do not find that the petitioner is at fault, nor appears to have violated the interim protection given to him, and therefore the period of interim bail is further extended for a period of 8 weeks from date on the same conditions as indicated in the said order.
I'm representing one of the all state representatives.
Yes. 7. Yes.
My father and mother, they are both Muslims, and
They are?
that they are in the private captivity of respondent number 1460.
Who are they?
They are the influential leader of the Human Communist Party. Actually, my mother contested the West Bengal Panchayat election. The total
Yes.
number of seats put out were 29. And they won 15 seats. And the TMC, they won 12 seats and 2 were independent. On the independent, they have gone to the against for their PP. Unless and until there is one more candidate or returning candidate that goes into their club, they will not be able to form the board. Now, if I can have also for on the complaint that I have filed before the police, now if you find it just in 24.
Yes.
The complaint, the relevant portion of it says that my mother and father, they are both in the captivity of the private respondent number.
No, आज बाड़ीते फिरे बाबा माँ के देखते ना पे then
मतलब हम बाड़ी सकते बाबा माँ के देखते ना के
अच्छा बाबा माँ के देखते I just read it बाबा माँ की ना देखते. Oh, after fire is a comma, is a comma. So one has to read in this way.
देखते ना पे स्थानीयদের থেকে জানতে পারি যে আপাতত
হ্যাঁ।
ব্যক্তিরা আমার বাবা মাকে
তৃণমূল নেতা কৃষ্ণ
দাস
বাড়িতে বাড়িতে আটকে রাখার হয়েছে. I can read better than you.
I'm trying now. খবর পেয়ে আমি
UPS student then
খবর পেয়ে আমি খুব দ্রুত কৃষ্ণ দাসের বাড়িতে গেলে সেখানে আমার বাবা মাকে বন্দী অবস্থায় দেখতে পাই এবং আমি সেই বাড়িতে প্রবেশের চেষ্টা করলে
করলে
আমার
মোবাইল ফোন কেড়ে নিয়ে yes
ভেঙে ফেলার চেষ্টা করে সারাদিন
where is a police officer? Why don't you go and find him? There is a serious allegation against this gentleman who is a respondent number. No, who is you have named respondent number 13. 13.
No,
Krishna Das, you have said.
other person is also there.
No, ওনার বাড়িতে দেখলাম বন্দি অবস্থায় আছে. So serious, correct. Where is why don't you
Malan, may
produce the by day after tomorrow?
Malan,
Just tomorrow,
Ma-
vote to be formed.
Malan, may I? May I?
Yes.
Malan, kindly see. First, you have seen, your lordship has seen this FIR. Malan, my respectful submission, this habeas corpus application cannot be maintainable.
Sure.
Yes,
Why not?
Lordship,
Why not?
yes, I'm coming. First, lordship, kindly
Why
come to
not?
the. Yes, lordship, kindly come to the paragraph.
If somebody has wrongfully confined a person in captivity,
Yes, lordship.
whether the habeas corpus does not lie, I just wanted to know from you.
Lordship,
Why not?
No, lordship, kindly. First, I will, one by one, lordship, I will satisfy your lordship's query. I understand lordship will, this query will come from your lordship, that I understand. Lordship, before that, I will satisfy in this regard. Kindly come to the nature of the petition, lordship.
Yes,
Lordship, kindly come, page 10, lordship.
yes,
Page 10, paragraph 7. From 7, 8, 9, 10, this is the very relevant paragraph, then I will.
yes.
May I, lordship? It is also pertinent to mention here that despite the complaint filed, the respondent authorities have miserably failed to register FIR against the private respondent. Number one. Number two, that the concerned police authorities have failed to take steps for impartial investigation. Next 9, lordship. That until and unless an independent agency investigates under the supervision of this honorable court, it will be very difficult to reveal the truth.
Yes,
Then, lordship, necessary permission may be granted under section 197 of the court for impartial investigation and the alleged officials may not misuse their power.
Yes,
This is the paragraph 7, 8, 19.
correct.
Lordship, now kindly see on the strength of the complaint on 31st July, Lordship, the allegation of at page 10, paragraph 7 speaks of that complaint has not been registered. Lord. This is my instruction. The FIR has been lodged and initiated,
Yes.
Lordship. This is number one, Lordship. Lordship, kindly see the concerned police authorities have failed to take steps, impartial investigation, and the independent agency and the supervision. This is the third. Now, Lordship, the Code of Criminal Procedure, either the 156 subclause 3
You are-
CRPC,
You are talking about the police in action.
Lordship,
We are not. I know.
Lordship, I will come. Lordship,
You can't omit the statements in paragraph 3,
Lordship, I will-
4 and
Lordship.
5 of the petition.
Lordship, this is the one, Lordship, I will definitely, Lordship, this is the part one fold of my submission. Lordship, I am coming to your Lordship's query, which your Lordship definitely happening in this.
No, I am conscious that he has to approach, if the FIR is not lodged, he has to approach the SP. Then thereafter, he will approach the court. I am conscious of those line of decisions of the Supreme Court.
Supreme Court,
There is no difficulty. in
no
this.
difficulties. Now,
I have
Lordship,
to approach
kindly,
it. Now,
yes, now,
what about the 3,
now,
4?
Lordship, kindly see, Lordship. Now, let us read the last paragraph of the affair. Last paragraph of the affair, because Lordship, আমি সেই বাড়ি থেকে পালিয়ে আসতে সমর্থ হই, এইটুকু পর্যন্ত Lordship has seen. সেই স্থানে থাকাকালীন জানতে পাই আজ রাতেই আমার অপহৃত বাবা মাকে কৃষ্ণদাস দলবল লাটাগুড়ির দিকে কোনো অজ্ঞাত স্থানে নিয়ে যাওয়া হবে। অতএব এমত অবস্থা আমি নিজ গৃহ থেকে বাইরে রয়েছি এবং উপরিক্ত অপহরণকারী কৃষ্ণদাস ও তার সঙ্গীদের দ্বারা আমার বাবা মায়ের যে কোনো রকম ক্ষতির অপরাধ হতে পারে। তো
So you see the anxiety of a son, you see.
my lord,
See,
I understand.
Definitely, the complexities and paraphernals, you just consider the anxiety.
Lordship, I definitely, Lordship, as equally,
And see what can
as
be done.
Lordship, equally, I am concerned to the with regards to the son, even Lordship. We understand the anxiety, Lordship, but we must have to be within the four corners of the law, Lordship.
Yes.
We cannot
yes.
go beyond the scope, Lordship. Now, Lordship, in the twofold in the FIR, there is a twofold complaint. Lordship, first, he said, it is the nature of this complaint is a missing right. But then the habeas corpus application would have been entertained. Here he said a specific complaint. That person has wrongfully detained the parents. A specific name has given. Now, definitely, whether the wrongful confinement and the detention, Lordship, that to be through investigation, it will come. Then the nature of, otherwise, had it been the case, the son has come. I do not know my father and mother. Now, Lordship, kindly come to the other way. Just logically, I am saying. Suppose my parents, they said that ওই আমাদের লাটাগুড়ির জঙ্গলে, maybe they are so happy in enjoying with the cordial.
So you see, unless the case is
Lot of the
instituted, you see, unless the case is instituted, interrogation done, then recovery, you see, all these things cannot be, these things will not come to light unless case is instituted.
Lordship, case has instituted.
Okay.
Lordship, that's why I say the first paragraph of 7. Right? When I am answering to the for a moment, when I am answering instructing, no, Lordship, I answering, I know I had received a better instruction. So, Malad, this affair has already been initiated.
And
on the-
thereafter, after incident,
Then, Malad,
so you are ready with the records that if
I am, the investigation is in progress, Malad. Investigation is in progress. Now, my question is that the person, suppose now in other way, suppose the political rivalry, Malad, kindly see, maybe because of my political allegiance, I am hiding myself to support my political party on the date of constitution of vote. Malad, it is a suspicious jurisprudence that habeas corpus will come. Court, it is on the basis of suspicion, Malad. Lordship, I know. It is very dangerous to Lordship, I understand. The second bouncer what will come, I know that. But Lordship, kindly appreciate. Kindly appreciate
see,
one.
everybody is in the dark. The son
Exactly.
and we are also in the dark.
Exactly, Lordship, we are also the dark.
Yes.
My police.
So what will be
official
the anxiety
agency-
if somebody is in the dark? You just appreciate. If somebody did
I
that,
am appreciating. That's what I said. We are equally concerned.
so what positive steps are taken by
Lordship,
you?
all the positive steps. Lordship, it is not the person. Lordship, we are not God, Lordship. Lordship, we are trying our level best to find out a person. Lordship, habeas corpus. Lordship, kindly see, habeas corpus, the Latin word, a body should be brought into the, from an unlawful authority. Unlawfully been detained. Lordship. And Lordship, I do not want to refer the judgment because again, Lordship knows very well. Lordship, kindly appreciate. The investigation is in progress. We are doing the investigation, all the intelligence branch and the other departments, there is a coordination below. We are coordinating with that. We hopefully that definitely with some positive response will come out. But Lordship, kindly appreciate, as I said, logically, because of political rivalry. Suppose, Lordship, I am hiding. If I am hiding, nobody will find it, Lordship. Then intent, Lordship, kindly, I understand, as my learned friend even felt that tomorrow the board or day after tomorrow the board will be constituted. No, my lord, in the board, a person, if he doesn't come, my lord, if he comes, then this Lordship application, automatically this application would be, because he is apprehending that he will not come, Lordship. And the board, definitely, my lord, what he said in the board, he is in the majority. And we are less than the majority. We are means the Trinamool, led party. So, my lord, kindly see a person wrongfully constrained or showing the allegiance towards the party. That is your suspicion, my lord. Under the suspicious jurisprudence, my lord, the habeas corpus in the nature of such writ application cannot be maintainable, my lord. Then, my lord, either the magistrate's inquiry, progress of investigation, or an alternative remedy, is efficacious remedy is not available, then the writ jurisdiction, my lord. This is a very, very rarest occasion, my lord. If the honorable courts find that such interference is required, but then definitely the nature of habeas corpus, where the direction would be given, the body to be brought, and maybe even Lordship kindly entertaining this application and direction be given. If suppose not given, that body to be brought, Lordship, I need some time, Lordship, and we are investigating. Definitely, we can come up with the progress of the investigation, nature of the investigation, in what extent we have gone into, in what extent we have undertaken all the efforts from the date of the registration of the FIR, my lord. So, in this nature, my lord, my all the officials are very diligent and very truthful, my lord. With humbly I can say in this regard, when your Lordship was equally shocked, we are also equally sure. Son is crying, then where our parents are there. And my lord, very interestingly, I will hand over one document which your Lordship will understand that what is the manufactured one. Lordship, the two affairs, what son said, my parents, someone had illegally confined him on 31st of July. My lord, kindly see this affair is a father. A father affair on 4th August. To the Superintendent of Police, Jalpaiguri, received by the office of the SP Jalpaiguri. Father said, same incident, my son is now missing. Now, Lordship, which one is in truth? That's why I said it is a suspicious jurisprudence where Lordship cannot entertain such read in the nature of habeas corpus.
You see, if that is, the case is already instituted, then the IO will have a copy of this. IO will investigate. This is a subsequent. This will have to be given to the IO.
That's why it's already.
IO will look into this.
Lordship, already it is given. My question is that now father is not in confinement or father is not missing. After this affair on 4th July, read petition discloses that parents are missing from a not missing, wrongfully confined. Father said my son is missing. Which one is the correct one, my lord? That's why I say maybe parents are enjoying the holiday after this long stretch of election, and or showing the allegiance to the party of which the board is going to constitute. So it's completely a suspicion, my lord. Father is saying now, son is missing. Yes. Yes. All case, CBI of the investigative agency, state also at the.
Not the two things that I carry from my learned friend. One is he is in dark.
Everybody is
in dark. I never use the word that my party is in majority. I said BJP is
in the petition.
He said, we are in minority. He is
Petition.
representing the party as well.
Petition, yes.
That's what he is doing here.
Yes, what I am doing in the petition.
They are all together.
I said in the petition.
Simply because of a democratic case.
Petition you said the BJP and the Trinamool Congress.
This is what is happening.
This is so far the petitioner is concerned, definitely we can appreciate the political motive is nothing.
We are not.
Simpliciter, he is anxious to see his parents.
Exactly.
This is the thing.
Exist lordship. Lordship, if the person complaint lodged against the person, if we ultimately we find that yes, he has been wrongfully confined. The person has been wrongfully confined. Then the person would be prosecuted.
Sir,
Sir,
one
my lord,
question. You have seen the complaint?
lordship.
You say that you are in a process of registering FIR or you have registered FIR. I find a dissent from your junior and you. Even your officer who is present has not agreed with your submission. Because I could see the body language of the officer. Be that as it may. When you say the investigation is in progress,
Lordship.
show us that you have visited the house of those persons
I'll come up tomorrow.
against you.
I'll come up tomorrow.
Today you have the documents.
Lordship, today,
Today,
to what?
we are giving a 15 minutes time. It is which here,
Then lordship, let us.
15 minutes time to
Lordship,
bring the
lordship.
documents.
Yes, lordship, I'll.
Show us
I
that
am, lordship, I am.
entire investigation
Lordship,
documents, bring, bring,
Lordship, I will.
bring within 15 minutes.
Lordship, kindly.
Within 15 minutes, bring
Lordship,
it.
Give us time at 1 PM. I'll come.
No,
I am
no,
here.
no.
I will not leave this
Give,
courtroom because lordship, I have a matter. I will not instruct my officer.
We are giving
I
you
will not
time.
instruct my officer.
12,
Lordship, I understand the apprehension.
12, 5, bring it.
Lordship, I am bringing. Give me a time.
Bring.
Lordship,
We
I
are
am
giving
leaving
you-
this court.
How much
Half
is
an-
the distance?
half an-
Officer is here. No,
Half an hour.
give
Yes.
12, 5.
Yes, Lord, half an hour. Yes, Lord.
12, 5. It is now 17 minutes. Bring him.
Lordship,
Bring him. Bring
all right,
him.
it
Bring
will
the
be-
document.
it will be plus 10 minus 10 minutes plus minus.
All the documents.
All
Bring,
10 minutes plus minus 10 minutes.
Bring. We are here. Just wait. Let him come.
I'm giving the instruction.
When I see already your duty.
Yes, he'll bring. You'll bring.
No,
What
no.
is Lordship directed?
Bring the file.
Yes, I'll bring. Yeah, I'm not bringing.
12,
I'll
5.
bring.
12, 5.
Yes, Lordship, I'll bring. Lordship.
Yes. For the
Lordship.
next matter. Just
Lordship.
wait.
Number 9.
CD to police call the
Yes. Yes. Which one? Nobody?
appeals and then let us patent.
आगे एक बार है नहीं कॉन्ग्रेस. They are not coming. Okay, Raja Visas.
Go to the list with liberty.
No, go to the list. आगे होइছে.
Next appeal will.
বলে দিয়েছেন সেটাই তো go out of the list. I mean, they are not interested. Discuss. Dismiss for call.
Number 10.
You are a third party. You are a third party to the proceedings. The leave has been granted. Where is the impugned order? Where is the impugned order? Which page?
There was a direction for us to file the affidavits that
Affidavit in opposition has already been filed.
filed by me, my lord. Filed by him, not by the state. Page 174 of this here.
This is an order dated 10th of August.
2020.
Just take your seat. Give me 30 seconds time.
Page 174. Okay, ঠিক আছে, এখানে ঠিক আছে, ঠিক আছে।
Now, the order appears to be very innocuous because the notice was given for a training. I do not know, that is for the training in as an auxiliary fire operator.
There is a section in the section of further action. There was a hardware decision at the infrastructure with the appellate was.
Correct,
That information was communicated upon the private respondent.
correct.
The private respondent what happened, suppressed the state act, and there was an order. That
What order was passed?
Just a month.
What order was passed? We don't go by the name, sir. Say High Court.
The respondent office was directed to file a short report with regard to the anomalies and irregularities in the course of in the recruitment process. And that report was duly filed for the signature. That report was suppressed and that particular order was suppressed because the.
No, what? Was there any interdict or interim order not to proceed with any further or something of that kind in your writ petition?
I have to check them.
You filed the writ petition, you do not know that you have to. That is what you say, that earlier to this, you filed a writ petition. In that writ petition, you allege various discrepancies, malpractices, which has been done by the authorities. The court directed the report to be filed. In this regard, you say that the report has been filed. I just wanted in your writ petition,
Yes.
was there any interim order relating to the recruitment or process or what? Anything? I just wanted.
There was, so there will be that effect was to file a reply to that particular report. Because submitting the particular order and the fact, the impute order was passed at the period of the private respondent. Thereby, we have to be and we important appeal because your honor report was. Now the appeal court was admitting this appeal was to pass a direction upon the respondent of all the parties. They filed today that
No, I understand they have filed it. I just wanted to close the entire issue.
Yes.
We wanted to close the issue. Now tell us that how you are aggrieved by this innocuous order, because this order says that since the authorities have already issued a letter for, I do not know, for training.
Yes.
So this training cannot be postponed eternally. You have to
Complete the training.
complete.
why the
Only question of appointment is concerned, I can understand. I can understand. The court has not passed an order for appointment.
training has been completed.
It's only for training. So let them undergo.
First, why I want to continue the loss, I want to continue the loss. I'm not right now.
Why, sir? This matter was listed.
I can differ.
Yes.
Why I'm believe this, what I'm different, that the person who has reported it in undergone training, they are not the competent person candidate because we have challenged the candidature because they have a number of irregularities in terms of their internet number and confidential all. That report that was indicated in the particular report by the DIG in our petition. So that needs to be looked into in the light of the report filed by the DIG and subsequently filed by the
Yes.
petition,
Yes.
by the private filed by the respondent. Both the readings to be taken into consideration. Thereafter, the supplementary my humble submission is that since the person who has reported it in undergone training,
Yes.
they are not the competent candidate because their competency has been challenged in my petition. And they have, and that has been admitted by the DIG in their report itself. To a list-
So-
to a great extent.
So the order in this particular appeal was that they can continue with the training. Have you conducted the training?
Yes, it's complete.
That's all complete.
It's complete.
Then what remained?
If third-party interest be created in the recruitment process, we will be prejudiced because we are we are challenging because we are.
But the trial court did not pass an order for recruitment
No.
or for the appointment. The,
because-
or the court simply says that once the training has been done and there is no interim order which is passed in this appeal itself. So if the court has said, please make an appropriate arrangement for conducting this particular training program. That is the only observation of the single bench. And this has already been done. This has already been done.
Yes.
Why it will go? And ultimately it is found that they are ineligible. Their training will not, they give them any kind of an additional one. Why you are difficult?
If they have, we have MRD, if
Let-
they reply,
let me-
if they reply, then that will be decided.
What decided?
That will be decided who are eligible, who are eligible.
Millard, if I may
Otherwise,
say, sir,
if all ineligible can will undergo training and they will get the appointment and they will regularize the work and the.
Absolutely.
During the procedure will go on and go on.
Nothing more. We are disposing of this since the training has already been done. If any, we are inviting us to make an observation that if any further appointment or engagement is done, then we'll say subject to the result of your writ petition.
yes, definitely.
They will indicate in
problem.
that appointment that this appointment is subject to the result of your.
Yes.
No difficult.
No difficult.
Why
No
they
difficult.
have not-
Millard, the difficulty is-
They are also shall not be finding-
Millard, what is happening here
এখানে
is,
শুধু ছিল ট্রেনিং এর জন্য চিঠি করেছিল ট্রেনিংটা করছিল না। ওরা এসে বললো দেখো যখন
I will be prejudiced twice.
Millard, there is no question of prejudice, I am.
Sir, why prejudice, sir? If the discrepancy or the fatal defects which you have projected in your writ petition is so enormous, then you could have been benefited with an interim order in your writ petition itself.
Right, right.
That not to proceed any further relating to.
If court done it, trial court had candidate submitted observe that since we are short for a short ABDP, short report, we are going to dispose of that application.
So you mention the matter, so mention the matter before the court. Mention the matter before the single
Millard,
bench.
the difficulty is.
Your
Millard,
matter
the
is go there.
entire recruitment
And the
process.
difficulty is since there was no appointment. This impugned order does not talk about any appointment because your concern is with the appointment. So it also does not talk about any appointment, only concentrated or was restricted to a training program which has already been done. So now if any further action on the basis thereof is taken, that will abide by the result of
Outcome
your
of the
writ petition.
report.
That's all. That's all. Finish.
The moment that.
What do you think? We are not hearing you. You are unable to answer the clinch or the real issue. That's the problem with you.
I'm trying to answer the.
Please.
The moment the application is disposed of,
Correct.
that will be operative upon the single bench.
Correct.
That's it.
Not operative of the single bench. Have you not understood what we are saying? That the scope of this appeal was restricted to a training. The court, while admitting this particular appeal, did not pass an interim order restraining the training to be restraining the training to be imparted to them. This court says that if the training is done, then it will abide by the result of the instant appeal. Now it appears in course of the hearing that you have already challenged the entire recruitment process,
Yes.
and that writ petition is pending. admitted position is, as you are saying, that there is no injunction order passed against the appointment. So we will simply say that the scope of this was only restricted to training, and the training has already been done. If any further action which they want to take, that would be subject to the result of your writ petition. If ultimately, if you succeed, then they have to go. They
Then
will
the
go.
appointment goes.
There are 2 points to add. Numbers. What is calling for your lawsuit? The training that has been imparted upon the private respondent lawsuit is the judicial with the partial to the impugned order. They have the impugned order has indeed been procured by suppressing the original facts of the pregnancy of the.
No, the state was
Absolutely, they
represented.
have acted.
The state was represented.
No,
We
state-
intimated the honorable court that there is no stay order from any single bench.
Court proceeding because the person, the official person was called upon in a particular chamber proceeding of the honorable court.
Huh?
And yes, where is it happened by?
What?
Here education.
What are you saying?
What
What are you saying?
We have not accepted by we have not been made part of it.
Then why, what you say? No, this is a serious one. No.
Information.
From where you got it? Just wait. From where you got this information? Yes. Yes. You were not in a picture in that. Then how you got the information? Yes.
We have not been made part in the proceeding.
Correct. No, we are talking about that incident. Yes, please. You have said something very serious. That's why we are saying. Tell us.
We have not been made party in the.
Correct.
Proceeding.
Correct.
Number one.
Correct.
Number two, the petition, the appellant were present in the court, but since they were not being party, they were not represented properly.
Correct.
But in that particular day, the concerned official was called upon.
Correct.
And he was asked, and he was asked to I don't know regarding the pregnancy of the other petition and all. I want that there should be party training. So this was done, and training was undergone, and that in the.
I understand.
In the impugned order. In this fashion, then the training was undergone. So we had immediately challenged the.
Sir, you are now detracting or you are detracting from your statement. You made one sentence.
Yeah.
You said, and we are taking an exception to that one sentence.
My it was present in the.
Have you stated in your petition?
I have checked it out because.
You have drafted the petition. You are moving a petition. You don't know. You don't know. Sir, this list was published yesterday. Have you not seen that this matter is going to be taken up?
At the outset, I can.
Have you stated this on oath that what you have said? Check it out from the file and then say. And if you say something in the bar, we are going to issue a rule against this. We will not allow any statement to come which would undermine the majesty and the sanctity of the court, High Court. Lakho,
Let my opposition.
the
be
copy
taken.
of let the opposition filed by the state
Lord, in 11, I'm for the petitioners. I'm being led by Mr. Charity who's on, is online.
No, ask me to manage Yes, sorry.
I am for the appellant hearing, my lord.
Yes, sorry.
Lord,
What
I
is
believe
this?
he has been muted.
What is the order? Which is included?
Lord will kindly take the last order, my lord.
Being led by Mr. Charity.
This is the order dated 12th of May.
22.
Yes,
my lord.
give us 10 minutes, 10 seconds time. Oh, the REIT is not maintainable, sir.
My lord.
My lord,
Lord, the facts can be better apprised by Mr. Charity. He's on.
my lord, lordship will
No,
kindly
admit
take
to
the
হয়ে গেছে। Automatically.
No, there's a slight limitation.
And there is a limitation.
Yes.
So
98.
have you served the copy?
We have just served it today.
Today you have served
Today.
and then you are moving it.
My lord, it was.
What are you doing?
It was listed.
How many days delay?
Sorry,
Lord, 98 days.
learned advocate appearing for the petitioner submits that the copy of the application for condonation of delay has been served upon the respondent today.
Today. my lord.
Stop. In view of the above, let this matter be listed in before the next subject. Call the next.
ওকে সময় দেবো না, এটা পড়বে আজকে 98 days, not 1 or 2 days. Length of the erasing material is the sufficiency of the process.
Appellant Lordship. So Lordship, in this matter,
There is a delay of 123 days, sir.
Lordship,
Have you filed a section 5?
no Lordship, that
Then-
I'm seeking time, Lordship.
What time? It appears from the report of the additional stamp reporter that the instant appeal has been filed beyond the statutory period provided therefore. So stop. There is no application for condonation or delay filed in connection with the instant appeal. In view of the above, let this appeal go out of list. In the meantime, the appellant petitioner shall take appropriate steps.
Lordship. Great.
Call the next.
Respond.
What they have challenged here. In a writ petition, they are challenging an order of transfer.
Yes.
From where to where?
But their blood, it can be, takes the order once. Shortcuts blood, order was blood that there's a temporary arrangement should be made by engaging a teacher in geography from a nearby school in terms of blood and notification, which was issued blood on 2021.
Where is the appellant? Ujjwal Rai, Mr. Devjit Kundu.
For Previously for single teacher cases, there was a bar, subsequently that bar was removed. Now in case of a single teacher, the DI
What bar? Where the bar was?
bar was for transfer. If
Where? Under what provision?
there was an earlier notification by the school education department. It
Okay,
said that in case of a single teacher for a particular subject, there shall be no transfer.
correct,
But subsequently that bar was removed.
correct.
In the subsequent notification, a further provision was made, wherein the district inspector of schools was asked to make an alternative arrangement by finding whether a teacher in the same subject is available in a nearby school. That proposal should be approved by the Commissioner of School Education.
Correct.
So that was a convenient arrangement that was made considering the interest of the school also. So that the shortest direction was calling upon the DI to make an alternative arrangement in this case, since the teacher claimed that she's
But
a.
So where is the difficulty? Because the transfer, she wanted a transfer.
They have raised a question of blood finance law that they are saying that their application was prior to that notification.
Oh, so retrospective effect.
Yes, but still Justice Shorter was the view that since the convenience of the school.
Then we'll have to hear.
Yes.
Then we'll have to hear whether it will operate retrospectively or prospectively. My judgment is against you.
Well, I'm aware of that was my submission.
That's a very recent judgment. Have you seen that judgment of Iris?
No, Millard, I could not. I apologize, Millard, I'll certainly look into it. Because I said, Millard, that the interest of the school also requires to be looked into, despite the lifting of the
So
bar.
you are a school service commission.
Yes. I'm a
So
school
will
service.
you not? It is within your domain.
No, Millard, the proposal has to come from the TI.
Under what provision of law?
Millard, that notification itself, the subsequent
But
notification.
can the notification runs counter to the section 10 of the West Bengal School Service Commission Act, 1997?
Millard, the proposal for transfer initiated by the DI, approved by the Commissioner of School Education, then if transmitted to the SSC, we are required to act upon it. So my role is yet to Millard to come into play as of now.
But
Until
you are a
Millard-
recommending body.
Yes, but I cannot do it considering the order of Justice Shorter. That is Millard.
That is a different issue.
Millard.
But the law mandates,
Yes, we are otherwise obligated to.
you are bound by section 10,
Yes, and there is a time limit.
section
also.
10A,
Yes,
10B
yes.
and 10C.
Right now, we are
So-
in a time bound manner also.
Do it. None of you. This
lord,
requires to be
My
heard.
lord,
Yes,
Ujjwala is in Calcutta, learned advocate.
So-
Kindly fix not today.
You will come tomorrow? Not today. Yes, come
Tomorrow.
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 Okay. Number 14.
বলো এসব কেউ যেতে চাইছে না একজন 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 Where is Miss Madhushri Dotto, Miss Sriya Basu?
I am for the regulated market committee.
The writ petition is dismissed.
Yes. And Millard, if my Millard kindly.
And the
see
defects have been removed.
Millard, I am not aware.
It is appearing from the day one, 31st ticket. This
This
is
order is Millard quite detailed, there are no infirmity at all. But kindly have a look at. order.
This is what it was. None appears in support of the petition. Appeal. করে দাও। Next.
15 may I request not today, my lordship. 15.
I am appearing on behalf of CJ.
Not today, my lordship.
Sir, there is a grievance of the bar that the mandamus appeals are not being taken up by the circuit judge. When we wanted to take up, then everybody is asking for an adjournment, then what can be done?
Tomorrow will.
Not
lord,
today.
kindly fix it a day after tomorrow. Tomorrow I have some family issues. And
Day after tomorrow.
grateful.
As prayed for করে দাও by the respective councils, day after tomorrow. And 16.
Shiv Shankar Banerjee Malat, he is appearing on virtual mode.
Is not.
Okay.
We do not find his name. Today is a date fixed for those matters. With the consent of the bar, those have been fixed. Then why you are asking for an adjournment? There's no-
Yeah, ascertain whether he has joined or not.
And I am for the respondent, my lord, the Hindustan Petroleum Corporation.
You appeared for the appellant. You are the advocate in record.
Record, but.
So do it. Do it. Whatever, do it.
Otherwise, my lord, I will do my lord, but
Oh,
client
do
has
it.
chosen senior to do the
So what?
matter, my lord.
If the senior does not appear, then what? You have to do it. No.
I'm ascertain, my lord. I'll have to do it.
Yes, you are for the Union of India.
No, my lord, I am for the Hindustan Petroleum Corporation, the transmitting respondent.
Union of India, nobody is represented.
Affidavit of service. Okay. বুঝতে পারছে না।
What is the date of the order of rejection?
51.
17 November.
Page 51.
17 November.
17th of.
And when the writ petition was filed?
Lord,
There's a delay, madam.
but it was heard on 1st of March, Lord, title of the writ petition.
9/2.
This presented petition has been.
9/2. Okay.
Affirmation is. Yeah.
Affirmation.
Have you already chosen the next one?
Yes, my lord, right. has
We have,
been written.
we have given it.
Yes, yes.
And there is permission for primary return. Correct. But
একসঙ্গে ছিল বলে উঠে গেল তো আপনার কাছে যেটা বলেছিলেন আমাকে ছিল তাকে 15টা পেলাম
Affidavits. Affidavits were invited.
It was dismissed at the first instance, madam. Madam, Mr. Banerjee is in online, madam, on virtual mode, madam.
would you like to commence the deputation?
So Banerjee, you were not,
I know, my lord, because of my technical defect, I could not join at time, lordship.
that's the biggest excuse which the lawyer always take,
No, so I'm
technical
sorry.
glitches.
No, sorry, my lord. Next time it will not happen. Technical is on my fault itself. I am not very computer savvy, so it happened with me, lord.
What remains, in this matter? You
Lordship,
approached the court at the very late stage.
Lordship, that is
There was another opportunity which was there in the contract documents itself, that you can make a representation.
true, lordship.
Simply they say you take a security deposit back. That does not mean that the right to representation goes. You still could have. You have not
True.
done this. Now a third party interest has been created.
True.
What
True.
to know? What to do now?
Now, lordship, only thing.
Except if the rejection appears to be wrong, you are entitled to damages.
No, lordship, it's not the question of damages, because I will actually not suffer that way of damage. I participated, but as a loss of no, lordship, what I'm saying, lordship, my representation probably would not stay, because they were in dialogue with me all along. Submit the deed.
Have
They
you
said change the deed.
have you stated all those in your
Lordship, I have stated to the
Where
extent
show us?
no, lordship, what I'm saying, lordship.
Show us.
Lordship, can there be a short report from them that what leads to this situation? Because
Why?
it's a very impractical thing. A report can be called for that how I
What
have
for?
negotiated. Lordship, kindly see.
What for? You
No,
have
Lordship,
not.
very,
I am
very
asking, Mr. Banerjee, you know
Lordship.
the importance of pleading
Lordship, that's not
in
there.
an
Lordship.
adversarial litigation.
No, Lordship, that's
system.
not there. That's
So
not there.
if it is not there, can you take it for the first time orally at the bar?
No,
You
I
can't.
know.
So
Lordship, this is.
if you cannot,
is-
then what?
Lordship, what only I am suggesting, if your lordship subject to your lordship accept that. Lordship, they can, third party has created. Now the tender has been floated. Now only thing they will see
No,
whether
tender
I
has
can
been,
be,
your tender was floated, you were found ineligible because of certain conditions being put. So now they have proceeded to
kindly see
complete
the
the
what is the
tender
condition.
process by allotting something. Have you
Understood,
already allotted?
understood.
They are
Understood.
functional. They are functional.
Not functional.
Not functional, that
Yes.
cannot be
So
functional
what
so
can be?
fast.
Whether
Lordship.
it's
But
a
they have-
long process, Millard knows there's a letter of intent, then
Okay.
dispensing pump and selling.
So it is only at a letter of intent stage, if I have understood
No,
them.
Millard,
It is,
agreement.
I understand. Lordship, kindly see my
Already
reason
entered
of
into.
rejection.
Probably, Millard, the construction they cannot see, that's why they are saying it is not
Ah.
visible, but the construction starts at a much later stage, after
Okay.
completion of several internal formalities.
Okay.
So Lordship, in this stage, of course, I can,
There's no
this is a reversible stage.
conformity in the
Then
process.
if I take my learned friend,
No,
then it
only
is a
thing is,
reversible
only
stage.
thing
Mala.
is because you have said so far as the site which he has offered does not confirm to your 300 meters, confirms to your conditions.
Yes, not my condition, it's
Uh-huh.
guidelines by the national.
Oh,
highway.
whatever, that's a
Yes.
condition.
Yes.
It does not confirm. They say that this is just on the opposite side of the road.
Mala.
But this distance from the intersection.
Yes.
Whether it is in this side or that
That side,
side.
it has to be within 300 meters.
300 meters. If
So
it is
that
left or
other
right,
side does not come within.
Does not make a difference.
Different.
Whether it's a left or right, 300 meters from the intersection is what we are
Correct.
going to measure.
So that
No.
was beyond that.
Beyond that.
So
No,
What-
Lordship
what-
accepted. This is what I wanted to explain, Lordship. In a no
Yes.
highway, it is a both side traffic. It is always a single side traffic. The
What?
very purpose.
What? Can you elaborate?
Lordship, in any highway, Lordship,
Correct.
there
Correct.
is a divider and there
Yes.
will be a one-way traffic, either this side and that side. It's not a without divide. So, Lordship, the very purpose of this.
Now there are several Asian highways where there is no divider.
So far as
No
this
difficulty.
highway is concerned, Lordship, this
Whatever,
highway,
yes.
except
So it is not a
Kolani Express.
universal. It is
No,
not
not
a
highway, Lordship,
universal
express.
notion in that. Yes.
no, Lordship,
Yes.
Lordship, in that case,
Yes.
particular in this particular highway, it is divided two sides. So if
Yes.
it is on the opposite side, why
Yes.
this division is made? Because if there is a cart and the car comes in for the petrol, there is a high chance of accident. So the
Yes.
purposive interpretation has to be given for this.
What
Now,
for
Lordship-
what purposive interpretation?
Lordship, purpose is
Oh.
why this 300 is the bar. I have to see why the bar is.
Oh,
Lordship, we
sir,
have-
when you participated in a tender process, did you not read that this is the condition which is there?
Lordship, it
If
has
you-
to be there.
Yes,
I support that
and
condition.
knowing fully well, being conscious that this is one of the conditions which is there, can you, after participation, take a rebound and challenge this?
No, Lordship. No, I
So-
cannot. I cannot. Lordship, in only in one case where the par.
No, sir.
Lordship, no,
No, sir.
Lordship, kindly
If you-
allow me 1 minute.
If you
more.
invite
Lordship, 1
invite
minute
me
more.
to deliver a judgment, I am ready to deliver a judgment on that score. That after participation, knowing fully well whether you can take a rebound, I can give you at least 5 judgments against you.
Lordship, what
Sorry,
I want
we
to.
can't.
No,
The
Lordship.
Supreme
Lordship,
Court
allow
has
me-
deprecated it. I was
I-
just thinking, I tell you very frankly, that when a 300 meters parameters are there, you were just trying to say that that was our impression, that they were contending that you should have this side of the road, since you have offered a other side of the road, so your case was rejected. Your contention, which we perceive, was that you are still within 300 meter.
Yes, that is.
So I was under that impression. But now when you say that putting a condition of 300 meter is unreasonable and
No,
should
I'm
not
not saying so.
stand
That's
on a
not my argument,
Wednesbury's principle, then
No,
I am sorry, I
Lordship,
cannot
Lordship, that's
accept
not
it.
my argument at all. That's not my
That is
argument
what
at
your
all.
argument is.
No, my argument is restriction is correct. Second, this restriction is to stop all bad incident or the accident. So, Lordship, we have to see practically when the interception is on the other side of the road. my interception is on the other side of the road, then whether it can hamper the purpose of that notification.
No,
Intersection
No.
cannot have a side.
No.
Intersection is an intersection.
Intersection.
No, Lordship. When a road is
No.
divided, highway
Sir,
is
sir,
divided.
there is also, I would say the interjection. Now I am using the word interjections
Yes,
in the dividers where you can go and take a U-turn and can
yes,
come.
Lordship.
There is
Yes,
no. Now,
Lordship,
now-
this
now-
is the case. Now,
Oh,
within three,
don't get so much, excited with certain observations. The second word is make your face sad. Don't worry. Only thing is when they say from an intersection within 300 meters, and if it appears that the land which you offered is beyond the 300 meters, the matter ends, whether this side or that side. That's all. And now if you say that this 300 meters criteria is wrong, I have the doubts. I appeared for many petroleum companies when I was on your side. And there is a norms that between two petrol pump or the retail outlets, there must be a distance of, I do not know now that norms has exchanged or something, 100 meter at that point of time was there. Now it has increased to 5. What the reason was very laudable. That two retail outlets should not be in a very close proximity.
But now, Milord, that has been allowed, Milord, subject to other conditions. It can be adjusted now also.
Correct. So at that
Keeps
point of
on
time,
changing.
there was.
Yes.
So that is what I'm saying. So you can't say the norms, if they have set up, knowing fully well you participated, you can't now say that it is wrong.
I'm not saying no.
It is beyond
No,
300 meters, that's the fault.
No.
Nothing.
Lordship, this is one way, it is beyond 300. Why? That's why when a Lordship said interjection, I make my face very happy. Why? From the interjection.
When I came back to intersection, your face is sad because they have sought. Who will go? The court will go and take a measure.
No, Lordship need not to. What I'm saying is, on the divider, sorry.
That has not been availed of.
Mobile tablet.
Thank you. Sorry.
No, Lordship, allow me one minute
Oh, sorry.
submission and then Lordship.
One
minute,
submission?
Lordship.
One submission? Yes.
One submission.
Yes. How
Lordship-
many sentences?
One sentences by one conjunction.
Correct. Yes.
If we measure the distance from
Yeah.
the interception or the interjection on the highway, it is beyond 300 meters.
Correct.
If it is a connection of a subway to a highway, that too on the opposite side of the road, that is within 300 meters.
Correct.
So if we say that the interjection has to be within 300, in my case, it is not applicable because there is no interjection or U-turn motive in the main road. So
Yes.
I do not come within 300 meters if the stretch of my side is taken. It
Correct.
is only on the other side, there is a road which is meeting the highway.
Yes.
And from that road, you cannot come to my side beyond a kilometer U-turn. So
Yes.
you have to go straight because in the highway, all connections are to the main road and then left turn. There is no right turn. If he wants to take a right turn, he has to go 1 kilometer and take a right turn.
Correct.
So purposive interpretation of this statute will be 300 meter from where it can reach to my place,
Correct.
not the aerial distance.
Absolutely.
It has to be the road distance. So
Correct.
they are applying the distance of 300 meter on a aerial mode. I am
Correct.
saying if you come by a roadway, it is much more ahead of 300 meters. It is
Correct.
more than a kilometer, the
Correct.
interception. But
Correct.
if you come by the aerial distance, then
Yes.
it is, then Lordship, it is within 300 meters.
Okay.
That's my submission.
That's
So
it. Thank
aerial
you.
distance should not be taken into consideration. The
Correct.
road distance, the length of the road has to be taken into consideration.
Yes. Thank you.
That's all, my lord.
Yes. Hey, this section 5 has been allowed.
No, nothing has been done, Lordship. I mean,
Section 5 has been filed. Yes, section 5 is not filed. No, no, এখানে আছে defective out of time. এটা দেখতে পাচ্ছি। You are not filing a section 5. You don't nowadays, you do not care to go through the stamp reporters. Yes, 10
It
days.
has not come.
It is very first. There is a note defective out of time. Will you not look at the file? Will you not look at on the reverse side of the first page of the memorandum what the stamp reporter has said? You are a veteran in the profession. You are not a newcomer.
No, my lord, it is mine.
So
My God, my lord, I have gone by the list because in the list it has not been.
do it tomorrow. Do it tomorrow.
I'm so sorry, my lord. I'm so sorry. I'm obliged, man.
Lordship,
I'm obliged on man.
Lordship, may I kindly mention about items 17 and 18.
Don't detain a hungry person. Mind does not work.
No, my lord, the can is not here written, my lord. That
Have
is
you
why.
not read that the old adage of the Vedikara? Even a prayer, offering a prayer to the God with the empty stomach will not do.
My lord.
So
Only, my lord, only subject to correction, my lord. Can is not here, my lord. This matter running from last circuit, my lord.
yeah.
And so lordship may should pass order, my lord, so that can come from principal bench, my lord.
I do not know. Have you filed in this matter the which was
Yes,
being
my lord.
taken up?
Principal bench, mat and can
That-
both come.
Sorry, the mat is here.
Yes, my lord.
Which matter?
Item 17 and 18, my lord.
We have been taking
My
16.
lord, 17 and 18, I am appearing for the income tax department, my lord.
Yes, come tomorrow. Let us see.
I'm grateful.
Obliged. Obliged.
বলছি There,
Sorry. No, we requested him to appear. So, no.
Lordship,
Yes,
Lordship, Mr. Srijit Chakraborty is appearing in this matter.
let
Kindly
it go in the
give-
next circuit. Yes, an accommodation is sought. Let this matter be listed in the next circuit. So,
Lordship,
no,
kindly-
definitely. Sorry.
Mr. Chakraborty
Yes.
has
Yes,
requested
next.
me.
so two is also appear.
Same, next circuit. Yes.
Grateful. I'm leaving.
Yes, call.
Item number 1.
Are you having a letter from your client? Oh, just one. So 13B has been filed? This CO arises from which order? Section 24. Uh, The instant revisional application arises from a matrimonial dispute. And an application under section 24 of the CPC was taken out by the wife, seeking transfer of the matrimonial suit number 275 within bracket 7 of 2019. Pending in the court of the additional district and session judge, fast track court Siliguri, to the court of the district judge Uttar Dinajpur at Raiganj. The matter was sent to the mediation. Stop. The report submitted by the mediator would reveal that the parties have agreed to settle their disputes. Stop. Let the report be taken on record. Since the original proceeding is pending before the additional district and session judge fast track court Siliguri, let the report of the mediation be sent to the said court for recording a final order disposing of the said matrimonial suit on the basis of the agreement arrived in the mediation's process. So the instant revisional application is thus disposed of. It has to go there. Yes, next. Next.
4. 5. 6.
Opposite party.
Where is Deboshi Dhar and Rajat Das?
On behalf of opposite party advocates.
No, I understand. But where are the petitioner? Today is you are a petitioner.
Kindly
Yes.
fixed on day after tomorrow.
Why?
Because the advocate of the opposite party request me instructed to fix the matter. Day after
You said you were appearing for the opposite party. Come tomorrow. Come tomorrow. Today is an exceptional day, I understand, but this matter was listed there.
From Darjeeling, my lord, so.
Let him.
after 2 years.
3 hours journey. How much? 3 hours? Let him come tomorrow. Yes, tell him. Yes. Tomorrow.
8, 9, 8, 8.
Yes.
7 and 8.
What about 6?
64 and 64.
Oh, this is 6 is CO 62. Yes. Yes, 9.
10.
Nobody is interested in civil matter. Move it. You are in item number 6 also. Oh, 6 you are not. Sorry, you are for the opposite party. What to do? Where is the petitioner? Call him. Not now. Then call him tomorrow. ROH civil revision. Put it. List all the civil revisional cases would be listed tomorrow from 2 p.m. Please inform